Ladies and gentlemen, if I could have your attention now, please. As you will know from the program material, the anchor speaker on this series of lectures is Mr. Justice Horace Krever. Mr. Justice Krever attended the University of Toronto and obtained his Bachelor of Laws there in 1954. It was called to the bar in that vintage year, 1956, and he and I both got through that terrible ordeal together. He was Queen's Counsel in 1970. He then went to practice after his graduation with Kimber and Dublin in Toronto and was engaged in counsel work until 1964 in all of the civil and criminal courts of this province. He has been a member of the Senate of the University of Toronto and has occupied so many other distinguished posts that I would not embarrass him by summarizing them here for you, but I must tell you that he has been a professor of the Faculty of Law of the University of Toronto, teaching civil procedure and evidence, and has lectured in medical jurisprudence in the Faculty of Medicine. He did that from 1964 to 1968, and then returned to do that again in 1974 to 1975. And in the meantime, he was professor of law at University of Western Ontario, teaching in civil procedure and evidence with special lecture in legal medicine in the Faculty of Medicine. He has been editor-in-chief of the Dominion Law Reports, the Interior Reports, and the Canadian Criminal Cases from 1967 to 1976. He was a bencher of your Law Society, and I'm sure he was a great deal of relief that he got rid of a lot of the burdens that I see here when he was appointed judge of the Supreme Court of Ontario in 1975. He's a good friend of mine, and I have great pleasure in introducing him to you today, Mr. Justice Krever.
Oh, I see. Doesn't go anywhere. Did you do that?
Put it on so many times, I think I can do it.
Thank you. I start off with a huge problem. This paper, which when you see it in print, will be quite extensive with a very large number of footnotes, and which I have to acknowledge at the outset as the product, the joint product of my law clerk, who has just departed for Australia to do graduate work, and myself, spends half of its pages and half of the footnotes on a subject that you've already heard about and had discussed probably in at least 3 different lectures, including one this morning. And that is the question with respect to the nature of the liability of lawyers and accountants, in brackets, whether it lies in contract or in tort, or whether there is concurrent liability in contract and tort, and it analyzes the conflicting case law and the debate between, for example, in the Court of Appeal, Madam Justice Wilson, Mr. Justice Laskin, when he was in the Court of Appeal, on the one side, saying contract, and Mr. Justice Jessup and Mr. Justice Zuber on the other. And you've heard about that, and I do not intend to spend my time, most of my time, doing what I had thought I was going to do and discuss that same problem again. I think it's unnecessary, and if any questions remain, they can be dealt with in the panel discussion. I just want to review it very quickly. There is a debate. The debate is not resolved. Not only is there a conflict in views among the members of the Court of Appeal, but since the Court of Appeal decisions, judges at trial have shown that the debate is still one that has to be resolved. And there is still the question of deciding, well, why is it important? What difference does it make? Is it academic? Are we back to the forms of action? Or is there, in fact, some consequence that results if you make the decision one way on the one hand and make it the other way on the other hand. And you've been discussing that. They are related, the consequences are related to the operative limitation period, which you've heard about. And when the limitation period starts to run, they are related, the views are, to the question of the measure of damages. If you decide they are, the liability is in contract, can you have problems of remoteness, which you've heard discussed? Can there be punitive damages awarded? Can there be damages for mental suffering? All of which are subjects in the paper and the cases dealing with the developments, very recent developments, I would say within the last 5 years, are canvassed. The next consequence of the decision in the resolution of the debate is whether you can have apportionment by reason of contributory negligence or contribution by other people, among other people. And there are recent developments in contract law in which there have been apportionment, where the liability is in contract. All of that I will not go into again. I just wanted to go through the headings again to review for you, to take your minds back to what you've already heard. My paper goes on to discuss some proposals for reform, very briefly, because I think you're more concerned with the practical implications rather than the law reformers' interest. But I think it would be short-sighted to fail to take into account current proposals for reform, particularly with respect to limitations law. I then will move into the second part of the paper, there being 3 parts in all, and this has to do with the liability of lawyers and accountants to third parties. And what I will do is not read the paper in extenso. It will be a truncated version of the paper you will eventually see if you ever have occasion to resort to it. The first part of this discussion will deal with the accountant's liability for the negligent disclosure of financial information. Since the landmark decision of the House of Lords in Hedley, Byrne, and Heller and Partners Limited in 1963, the courts have attempted to define the circumstances which will give rise to a tortious duty of care in respect of negligent misstatements. The principal concern of the courts has been to fashion a set of principles which will recognize the legitimate interests and expectations of the public, but will also place a reasonable limitation on the liability of negligent statement makers. I apologize for this touch of laryngitis. You just have to bear with me. You're fortunate that I'm not going to be as long as I otherwise would have been. This problem has been addressed in recent cases which have considered the proper scope of an accountant's liability to third parties who suffer losses through reliance on financial statements prepared by the accountant. In Hedley Byrne, the law lords enunciated a principle of liability for negligent misstatements which is somewhat more restrictive than the neighbor principle laid down in Donahue and Stevenson. The majority of the House of Lords were of the view that for the purpose of determining the scope of liability in any given case, a distinction ought to be made between negligent acts causing physical damage and negligent words causing financial loss. The most succinct expression of the policy reason for limiting the scope of liability for economic loss resulting from negligent misstatements is, of course, American. It's the oft-quoted dictum of Chief Justice Cardoza in Ultramares Corporation and Touche. This is the dictum. If liability for negligence exists, a thoughtless slip or blunder, the failure to detect a theft or forgery beneath the cover of deceptive entries may expose accountants to a liability in an indeterminate amount for an indeterminate time to an indeterminate class. The law lords adopted a cautious approach to the establishment of this new duty of care by requiring a closer nexus between the parties in these circumstances than is contemplated by the reasonable foreseeability or proximity test. They prefer to speak in general terms of circumstances involving a special relationship between the parties and reasonable reliance on the information and advice, and did not attempt to define the precise circumstances in which the new duty of care would arise. As Lord Pearce noted, How wide this sphere of the duty of care and negligence is to be laid depends ultimately on the court's assessment of the demands of society for protection from the carelessness of others. The Supreme Court of Canada had occasion to consider this question in the case of Haig and Bamford in 1977. There, a firm of chartered accountants prepared a financial statement for a client with knowledge that the statement would be used to influence investment in the client's business by a limited number of persons. Mr. Justice Dixon put forward 3 different tests upon which a duty of care could be founded. First, foreseeability of the use of the financial statement and the auditor's report thereon by the plaintiff and reliance thereon. 2, actual knowledge of the limited class that will use and rely on the statement. Or 3, actual knowledge of the specific plaintiff who will use and rely on the statement. Mr. Justice Dixon opted for the second test, actual knowledge of the limited class that will use and rely on the statement, holding that it was unnecessary for the accountants to have knowledge of the specific plaintiff in order to incur liability. It was sufficient to establish a duty of care if the accountants had knowledge that the financial information is passed, and I'm using his words, to members of a limited class whose identity is unknown to the accountant in furtherance of a transaction, the nature of which is known to the accountant. It should be noted that Mr. Justice Dixon specifically left undecided whether or not the test of foreseeability is a proper test in determining the full extent of the duty owed by accountants to third parties. He remarked in a general way about the expanded role of accountants in modern society. This is what he said: "The increasing growth and changing role of corporations in modern society has been attended by a new perception of the societal role of the profession of accounting. The day when the accountant served only the owner-manager of a company and was answerable to him alone has passed. The complexities of modern industry, combined with the effects of specialization, the impact of taxation, urbanization, the separation of ownership from management, the rise of professional corporate managers, and a host of other factors, have led to marked changes in the role and responsibilities of the accountant and in the reliance which the public must place upon his work. The financial statements of the corporations upon which he reports can affect the economic interests of the general public as well as of shareholders and potential shareholders. Policy considerations, such as those mentioned by Mr. Justice Dixon, must be weighed against the concern about unlimited liability in the determination of the proper scope of accountants' liability to third parties. It's interesting to note that the reasonable foresight test has been adopted recently in 2 jurisdictions outside Canada. First, in Scott Group Limited and McFarland, the New Zealand Court of Appeal was concerned with the liability of accountants to a person who suffers loss by relying on financial statements to make a successful takeover of a company. In that case, the auditors had no direct knowledge that a takeover was contemplated by any party. The majority of the court applied the test of reasonable foreseeability in holding the accountants liable. And I will not read very much from that judgment. There is an extensive series of quotations dealing with with the problem, but I leave that to be read rather than to be listened to. In the recent case in England of J.E.B. Fasteners and Marks Bloom & Company in 1981 is the other outside Canada case. In that case, Mr. Justice Wolfe applied the approach enunciated by Lord Wilberforce in the Anns case, which is Anns in London Borough of Merton in 1977, and did so in circumstances similar to those in the New Zealand case. He held that the appropriate test for establishing whether a duty of care exists appears in this case to be whether the defendants knew or reasonably should have foreseen at the time the accounts were audited that a person might rely on those accounts for the purpose of deciding whether or not to take over the company and therefore would suffer loss if the accounts were inaccurate. Mr. Justice Wolfe thought that the reliance requirement in Headley-Byrne was a sufficient limitation on liability to overcome the danger raised by Chief Justice Cardozo in the Ultramarys case. Under this test, the plaintiff would be required to prove, 1, that it was all times reasonable or foreseeable that he would rely on the negligent statements, and 2, his reliance on the statement caused his loss. Mr. Justice Wolfe was also of the view that there were no considerations which should exclude the prima facie duty of care in the circumstances of the case. In the result, the defendants were held not to have caused the plaintiff's loss. Even though the plaintiffs relied on the statements, they would not have acted differently had they been aware of the inaccuracies, since their main objective in taking over the company was to obtain the services of its 2 directors. I go on in the paper to discuss developments in the U.S. law after ultramarys and touche, which of course was a decision of a Court of Appeals in New York, at which time, during the time that that Cardozo was Chief Justice of that court. But I will not take the time now to say more than that. You will find a discussion of the American cases, or some of the more important ones and leading ones in the paper. The question of the proper scope of an accountant's liability to third parties who suffer loss in reliance on financial statements prepared by the accountant will necessarily involve a policy determination as to who, in the particular circumstances of each case, is best suited to bear the risk of professional negligence. The wider test of reasonable foreseeability has yet to be specifically addressed by the Canadian courts, although I point out that in a recent case from Quebec, Dupuis and Pan American Mines Limited in 1979, reported, as far as I know, only in the business law reports, Mr. Justice Nolan of the Quebec Superior Court said, without reference to authority, when an auditor prepares a balance sheet which he knows is going to be inserted in a company prospectus offering stock for sale, I believe he has a duty to make sure that the contents of that balance sheet are accurate so that prospective investors will not be led into error by it. As I say, we'll have to await further developments in the law as they relate to the liability to third parties on the part of accountants. Let me turn to liability of solicitors to third parties. And although I can imagine other cases, other types of cases in which the problem arises, the two cases that I will mention are cases involving the disappointed beneficiary under a will. The last few years have seen a new development in the law which is of great importance to solicitors and to tort law in general. In these two cases, a solicitor has been held liable in negligence to a third party, a beneficiary under a will, and therefore a person with whom the solicitors, or the solicitor in each case, was not in a contractual relationship, after the beneficiary's spouse had witnessed the will, thus rendering the gift void under the relevant wills legislation. In the British Columbia case of Whittingham and Crease and Company in 1978, the defendant's solicitor had drawn up a will under which the plaintiff was a residuary beneficiary of most of his father's estate. The defendant, the plaintiff, and the plaintiff's wife were all present for the execution of the will, at which time the plaintiff's wife witnessed the will at the behest of the solicitor. This action rendered the bequest to the plaintiff invalid under the Wills Act of British Columbia, and the result was that most of the estate went on an intestacy to be shared by the plaintiff and his brothers, whereas had the will been effective, he would have got all of that portion of the estate, which was most of it. Mr. Justice Aikens was of the view that the principles discussed in Hedley Byrne and Haig and Bamford were applicable in these circumstances to the extent that they were concerned with an undertaking of responsibility by one party, together with reliance by another party on representations made pursuant to such undertaking. He found in these circumstances that the solicitor had undertaken the responsibility to see to it that the will was correctly signed and witnessed so as to be an effective instrument, and that the plaintiff had relied on the implicit representation made by the solicitor that the will would be effective if witnessed by the plaintiff's wife. After quoting from the speeches of the House of Lords in Hedley Byrne concerning the formulation of a duty of care, he said, "It appears to me that one may properly invoke a relationship equivalent to contract," in quotation marks, or, quote, "undertaking of responsibility," end quote, or both. Perhaps the question of whether to do so essentially comes down to what Lord Pearce said in Hedley Byrne at page 536, which I repeat here for convenience. How wide the sphere of the duty of care and negligence is to be laid depends ultimately upon the court's assessment of the demands of society for protection from the carelessness of others. While I am not free, said Mr. Justice Aikens, to make pronouncements on such a broad basis without authority, I am of the opinion that the factual situation in the present case falls fairly within the principles enunciated in Hedley Byrne and expounded in Haig and Bamford. I hold that in all the circumstances, Mr. Cowan was subject to an implied duty to the plaintiff to use reasonable care and skill and diligence in attending to the witnessing of the testator's will. Mr. Justice Aikins was troubled by the fact that no other cases following Hedley Byrne had involved circumstances in which the plaintiff had not done any act, as the plaintiff in his case had not, in reliance on the representations made by the defendant. He noted, however, that it was reasonably foreseeable that the solicitor's negligence would itself cause the loss, and said, "It seems to me on principle that it is immaterial that the plaintiff himself did nothing in reliance on the implied representation made by Mr. Cowan, which brought about his loss. This is so because the negligence of the solicitor caused the loss without there having to be any intervening act by the plaintiff to perfect the chain of causation." The English case, the corresponding English case of Ross and Conters, is a decision of Vice Chancellor McGarva, and he took a somewhat different approach to the question of liability in a fact situation virtually identical to that found in the Whittingham case in British Columbia. Although he recognized the validity of applying the principle of Hedley Byrne to the creation of an implied duty of care in such circumstances, he preferred to analyze the question of liability under the general principles of proximity and foreseeability established in Donoghue and Stevenson and developed in Ann's and London Borough of Merton. From his judgment, I quote the following instructive passage, which has the ring of Donoghue and Stevenson, it seems to me. "A solicitor who is instructed by his client to carry out a transaction that will confer a benefit on an identified third party owes a duty of care towards that third party in carrying out that transaction, in that the third party is a person within his direct contemplation as someone who is likely to be so closely and directly affected by his acts or omissions that he can reasonably foresee that the third party is likely to be injured by those acts or omissions." So one can see that the Vice Chancellor restricted the scope of liability to those situations involving the bestowal of a benefit on an identified third party. As I said, I think there are cases that will come before the courts in which the third party is someone other than a beneficiary under the terms of a will, in which there has been an error made by the, in respect of which an error has been made by the solicitor. But I haven't come across any others that would make, I haven't come across any others, as a matter of fact, to be quite frank about it. I turn now to my last topic, and I'm a little bit embarrassed about it because it's a subject on which I have written a judgment, and I feel somewhat defensive about it because I think it's not a popular judgment. Now that doesn't distinguish this judgment from a lot of other judgments I've written, but except for the fact that the lack of popularity of this one is among lawyers. And I speak of the barrister's liability in connection with the conduct of proceedings in court. The case I'm speaking of is DeMarco and Ungaro, a decision reported in 1979. But before that decision, there was remarkably little Canadian authority on the question whether a barrister enjoys immunity from action in connection with the conduct of proceedings in court. The law in England has recognized such immunity for well over a century. The historical rationale for the immunity was based on the division of the profession in England into barristers and solicitors, and on the fact that the barrister has no contractual relationship with the client and cannot sue for his or her fees. The solicitor, of course, does have a contractual relationship, but the barrister is retained by the solicitor, and there is therefore not that nexus between the client, so it is thought, and I suppose that's the case in law, between the client served and the serving barrister. In the Upper Canada case of Leslie and Ball, which was in 1863, it was held that such considerations were inapplicable to the situation in the province where there was an undivided profession and where lawyers often acted as both solicitor and counsel in a given matter and were entitled to sue their clients for fees in respect of services rendered. It was therefore decided in that case that barristers were not exempt from liability as a result of the negligent performance of their duties in court, and much or though it is thought that DeMarco and Gerard changed the law if you look at the case and look at it objectively, I think, though, and here I am being defensive, I think you will find that what I say is that's always been the law in Ontario, even before Confederation. And so there's no change in the law, except in people's perception of the law because of the next case I mentioned. And that goes back to our continuing habit of looking to see what the English courts say and automatically assuming, well, that must be our law because it used to be our law. Our habits of thought haven't changed. In Rondell and Worsley in 1967, the House of Lords had an opportunity to consider afresh the question of barristers' immunity. The Law Lords' decision to retain the concept of immunity was based on specific considerations of public policy. If ever there was a case in which the decision was based on policy factors and expressly stated to be so, that it's Rondell and Worsley. DeMarco and Ungaro provided the opportunity for an Ontario court to re-examine the issue of whether this concept ought to form part of the law of Ontario in light of the policy concerns articulated by the Law Lords in Rondell and Worsley. And I thought the problem in the DeMarco and Ungaro case was not should I change, not whether or, put it differently, I did not change the law, but I had to consider whether I should change the law in Ontario if I were persuaded that the reasoning in Rondell and Worsley made sense for Ontario. My view was, as I said, that the public interest in Ontario does not require that our courts recognize an immunity of a lawyer from action for negligence at the suit of his or her former client by reason of the conduct of a civil case in court. The notion of a barrister's immunity constitutes an exemption from the duties implied by the law which arise from other professional relationships. The policy considerations which led the House of Lords to uphold the exemption can be summarized under 4 headings. There was one law lord, and I think it was Lord Pierce, as I recall, who did say it's still based on the fact that a barrister can't sue for his fees. But I think he was alone. As I recall, he was alone. And there were 4 different bases of public policy. First, a barrister's duty to the court is superior to the duty to his client. In the absence of immunity, the barrister's belief that he owed a greater duty to his client would lead to prolixity and protracted litigation. Second, an action for negligence against a solicitor, that should be a barrister, would involve a relitigation of the original action, or the original case. That is to say, the case in which the barrister had done the bad job. Third, a barrister is under an obligation to accept even the most undesirable or difficult client who seeks his services. And fourth, to hold him or her liable for his conduct in court would be inconsistent with the absolute privilege enjoyed in respect of anything said by a lawyer in court. As to the first ground, the prospect of protracted litigation, it does not seem to me to be serious enough to justify denying a remedy to an aggrieved client. It is unlikely that the specter of subsequent litigation would cause a lawyer to alter his or her approach to the conduct of a trial in a manner which would compromise the duty which is owed to the court. Moreover, even though the decision in Leslie and Ball in 1863 in Upper Canada refused to recognize the concept of immunity in Ontario, the incidence of negligence actions against barristers up to the time of the decision in Rondell and Worsley did not reach serious proportions. Second, although relitigation of the original action may not be desirable, it may be unavoidable. In any event, it seems to me that it is preferable to the alternative of foreclosing the possibility of a remedy to a client who has suffered loss through no fault of his or her own. In addition, it is doubtful whether a lawyer in Ontario has a duty to accept any client, that is to say, any client who seeks his or her services. In my experience, which I think is as extensive as most people's, This certainly does not appear to be the case in the context of civil litigation. I've never heard it said, whatever the debate may be with respect to the criminal law, that a lawyer has to take any client, whether he likes the case or not. I've never heard it said that a lawyer involved in civil litigation must act for someone who seeks to retain him or her. Finally, the fact that a lawyer may owe a duty to his or her client to use reasonable skill and care in the conduct of court cases does not seem to be inconsistent to me with the absolute privilege which he or she enjoys as a participant in a judicial proceeding. I don't suggest for a moment that the law is not that a person who is acting in a court case in court is immune, say, in the case of a libel or a slander action arising out of the court case by reason of something that the lawyer says in court in the conduct of it. But I don't know that that necessarily follows from that kind of protection that the protection needs to be extended to any act done by a lawyer in the conduct of litigation. Which brings me to the next important decision in the English House of Lords. In Saif Ali and Sidney Mitchell and Company, the House of Lords had occasion to consider the scope of the immunity principle which had been reaffirmed in Rondell and Worsley. The litigation in that case arose out of a civil action in which a barrister allegedly gave negligent advice to the plaintiff's solicitor as to who should be joined as defendant to his client's claim for damages following an automobile accident. The solicitor accepted the barrister's advice, and the upshot was that the plaintiff's action against certain potential parties became statute barred. He sued his then solicitors for negligence, who in turn issued a third-party notice against the barrister. On appeal from the Court of Appeal's order that the third-party notice be struck out, because barristers are immune, the House of Lords essentially engaged in an exercise in drawing a line between the conduct of a barrister, which should be protected by the concept of immunity, and that which may attract liability. Lord Wilberforce adopted the test established by President McCarthy of the New Zealand Court of Appeal in Rees and Sinclair, a decision of 1974. And I quote, "But I cannot narrow the protection to what is done in court. It must be wider than that and include some pre-trial work. Each piece of before-trial work should, however, be tested against the one rule, that the protection exists only where the particular work is so intimately connected with the conduct of the cause in court that it can fairly be said to be a preliminary decision affecting the way that cause is to be conducted when it comes to a hearing." End of quotation. My reading of the speeches for the majority in Saif Ali indicates that they favored restriction of the scope of the rule established in Rondell and Worsley in view of the potential injustice which could befall an aggrieved client. It should also be noted that Lord Diplock rejected the argument regarding counsel's duty to accept troublesome clients as a ground for establishing barrister's immunity. He said, "True it is that he may be obliged to accept instructions on behalf of an obstinate and cantankerous client who is more than likely than more rational beings to bring proceedings for negligence against his counsel if disappointed in the result of his litigation, but the existence of this risk does not, in my view, justify depriving all clients of any possibility of a remedy for negligence of counsel, however elementary and obvious the mistake he had made may be. There are other and more specific means of disposing summarily of vexatious actions." End of quotation. In my view, the policy concerns outlined in Rondell and Worsley are not persuasive enough to displace what I perceive to be the countervailing public interest in Ontario in affording a remedy to those clients who have suffered loss due to the negligence of counsel in the conduct of civil proceedings. The notion of public interest comprehends values generally held by a community as a whole and not just one professional group. The public interest must be viewed in light of the fact that all lawyers are required to carry errors and omissions insurance in respect of negligence in the conduct of their clients' affairs. And no distinction is made between whether they're doing solicitor's work behind the desk or barrister's work in the courtroom, with respect to the requirement that they carry liability insurance. Like other professionals, the lawyer holds himself or herself out as possessing a certain degree of skill and experience in a particular field of human activity. Given the expanded role which many professional people play in modern Ontario society, and in view of increased incidents of negligence and malpractice actions and of other recent developments in the law of negligence, I question whether it is in the public interest to grant barristers in civil proceedings an exclusive immunity enjoyed by no other professional person. It should be emphasized that the only issue decided in DeMarco and Ongaro, the reported case, was the right of a client to sue his lawyer for negligence in the conduct of civil proceedings in court. That should be the conduct in court of civil proceedings. The negligence of counsel in those circumstances will remain subject to strict proof by the plaintiff. In DeMarco, I said, indeed, I find it difficult to believe that a decision made by a lawyer in the conduct of a case will be held to be negligence as opposed to a mere error of judgment. But there may be cases in which the error is so egregious that a court will conclude that it is negligence. In Karpenko and Peroyan, Corey, Cohen, and Houston, a decision reported in 1980, Mr. Justice Anderson considered the question whether a lawyer's decision to recommend settlement was negligent. He was of the view that it would only be in, and I'm using his language, a clear and exceptional case that such a decision could be successfully assailed. After noting that it was in the public interest to encourage the settlement of cases and recognizing the potential danger of employing hindsight to evaluate the decisions of counsel, Mr. Justice Anderson said this: I can think of few areas where the difficult question of what constitutes negligence, which gives rise to liability, and what constitutes at worst an error in judgment, which does not, is harder to answer. In my view, it would be only in the case of some egregious error, to use the phrase adopted by Brother Krever and DeMarco, that negligence would be found. The unwillingness of the courts to second-guess the actions of counsel can also be seen from a very recent case of Wexel and Stutz, reported in 1980. In that case, the plaintiff sued the defendant alleging negligence in the conduct of an assessment appeal before the Ontario Municipal Board. In particular, it was alleged that the lawyer had failed to cross-examine the opposing assessors or to cross-examine upon documents filed on behalf of the assessment department. In dismissing the action, Judge Morrissey said this: a counsel cannot be bound by strict rules as to the manner in which he conducts a trial. The extent of cross-examination of a witness, or indeed whether he should be cross-examined at all, must be left to the judgment of counsel. If in the judgment of counsel a witness cannot be broken down, or at least the impact of his testimony reduced, it is sometimes preferable to forego cross-examination. Cross-examination in some instances can result in a strengthening of the evidence by mere repetition. As mentioned earlier, the defendant was an experienced counsel, and if in fact he refrained from cross-examining witnesses, it is reasonable to conclude that he had a reason for so refraining. As with other professionals, the law will only compensate injured parties for negligence and not errors in judgment on the part of barristers and solicitors. It would appear, at least from a review of the reported cases in Ontario up to this point, that the low incidence and success rate of negligence claims against counsel in civil proceedings may have dispelled some of the apprehensions which may have been felt by some members of the practicing bar following the release of the judgment in DeMarco. Nevertheless, it is in the public interest that aggrieved parties be afforded the same rights of compensation against counsel in civil proceedings in court as they are against all other professional practitioners, in my respectful opinion. I conclude with a footnote. When I referred to the DeMarco case a minute ago, I said the reported case. DeMarco and Ongaro came to trial last week. And the only report I have of it is from, now 10 days ago, rather than last week, is from the St. Catherine's Standard. And I've confirmed the reliability of what it concludes, though if I were relying only on the report in the newspaper of it, I've had some doubt about it because of my wondering whether the reporter understood what the case was all about. One finds in the first day's coverage of the trial, I'll tell you in a moment how the trial ended, but the first day coverage has this paragraph. After explaining what the case was about, there's a paragraph that says, before this suit could be launched, Mr. DeMarco had to get a court ruling saying that civil lawyers could be sued for negligence. This is the first time in Ontario that a lawyer is being sued for negligence by a former client. What appears to have happened from the story in the paper and the confirmation of that story by the trial judge was Mr. Justice Griffiths, was that in the cross-examination of the plaintiff, I'm giving a judgment here, but I think the judgment is borne out by the recital of the evidence in the newspaper. The plaintiff was discovered to have been involved in a colossal fraud and a fraud on the court in changing documents, bank documents, to suit his case against the lawyer. It became clear in the cross-examination from what is set forth in the newspaper that that was so, and the plaintiff's lawyer asked for a recess in the cross-examination. And then the paper says, in the second story covering the trial, I'll read it from there on. At that point, at the point of the request for the recess, at that point, court recessed for half an hour while everybody involved met behind closed doors. When court resumed, Mr. Campbell, plaintiff's solicitor, counsel, asked that the action be withdrawn. I understand it's actually to be dismissed, said Mr. Justice Griffiths. Then he dismissed the case, saying, regretfully, I have concluded from the evidence of Mr. DeMarco that I could not accept him as a credible witness in this case, the judge said, ruling that each side pay its own costs.